I am Professor Rashmi Raman, and this module is titled Defenses under International Law. In this module, we will discuss the defenses of duress, obedience to superior orders, and other important defenses. What are the learning outcomes in this module? Firstly, for you to have a knowledge about defenses under international criminal law. Secondly, for you to have insight on Article 31 to 33 of the Rome Statute that codify these defenses. And finally, for you to understand the defense of obedience to superior, which is in direct contradistinction to respondeat superior that you have discussed in a foregoing module. Let us now talk about the importance of having defenses in international criminal law. In its simplest sense, a defense represents a claim submitted by the accused by which he or she seeks to be acquitted of a criminal charge. It is an answer to a criminal charge and is used to denote all the grounds which for one reason or another hinder the sanctioning of an offense, despite the fact that the offense has fulfilled all the definitional requirements laid out for a given crime. Since a criminal offense is constituted through the existence of two cumulative elements, that is the physical act or actus reus and the mental element or mens rea, the claim of defense would only succeed if either of these two elements were to be disproved. How does one go about disproving either of these two elements? Domestic criminal legal systems tend to distinguish between defenses that may be raised against any criminal offense, that is general defenses, and those that may be invoked against particular crimes, that is special defenses. Another point of distinction is that between substantive and procedural the difference between substantive and procedural defenses. The former refers to the merits as presented by the prosecutor, while the latter are used to demonstrate that certain criminal procedure rules have been violated to the demerit of the accused, with the consequence that the trial cannot proceed on its merits. The defenses to international crimes, however, tend to fall into slightly different categories. These are discussed in Articles 31 through 33 of the Rome Statute of the International Criminal Court, and this can be considered an authoritative statement of defenses currently accepted in international criminal law. Article 21 of the Rome Statute allows a broader approach to be taken with respect to defenses for international crimes. As implied in Security Council Resolution 808 of 1993, this approach is in keeping with the ICTY precedent, whereby the United Nations Secretary General had advocated that silence in the instrument did not mean that other defenses could not be considered, drawing upon general principles of law recognized by all nations. The Rome Statute partially codifies available defenses in Article 31, 32 and 33. Article 31 deals with 4 substantive grounds for excluding criminal responsibility, and these are the defenses of mental illness or defect, the defense of intoxication, the defense of self-defense, and finally duress or necessity. This list is not exhaustive. Article 21 may be referred to in order to check other grounds for excluding criminal responsibility. Article 32 addresses the defense of mistake of fact or mistake of law, while Article 33 deals with the defense of superior orders and the prescription given under law. Let us study one by one the defenses under Articles 31 through 33 of the Rome Statute. Article 31. Let's look at the text of Article 31. Article 31, Clause 1, Subclause A of the Rome Statute deals with the defense of insanity and excludes criminal responsibility if the actor, due to a mental illness, mental disease or mental defect, is not able to recognize the unlawfulness of his conduct and or to control it according to the requirements of the law. Article 31 1A reads as follows. A person shall not be criminally responsible if A. the person suffers from a mental disease or defect that destroys the person's capacity to appreciate the unlawfulness or nature of his or her conduct, or the capacity to control his or her conduct to conform to the requirements of law. Upon extrapolating the elements of Articles 31(1)(a), and despite several submissions by the defense in various cases, mental diseases or defects as grounds for excluding criminal responsibility have not yet played an important role in the jurisprudence of international courts and tribunals. Based on Rule 61 of the ICTY Rules of Procedure and Evidence, the ICTY distinguishes between insanity and diminished mental responsibility. Now, this is not a defense stricto sensu, but accordingly, insanity requires that the accused is, at the time of commission of the offence, unaware of what he is doing or incapable of forming a rational judgment of right and wrong, while diminished mental responsibility, which is not really a strict defense, is based on the premise that while recognizing the wrongful nature of their conduct, the accused, due to this diminished mental responsibility and mental abnormality, is unable to control their actions. Thus, the exclusion of responsibility pursuant to Article 31(1)(a) appears to have two requirements. Firstly, that there must be a more than momentary defective mental state, and this cannot be a psychological or emotional state. Two, that the absence of the capacity to cognitively appreciate the unlawfulness of the conduct or to control it volitionally, that is voluntarily. Let us now turn to 31(1)(b) of the Rome Statute. 31(1)(b) deals with the defense of intoxication. The article itself reads as follows. A person shall not be criminally responsible if the person is in a state of intoxication that destroys the person's capacity to appreciate the unlawfulness or nature of his or her conduct, or capacity to control his or her conduct to conform to the requirements of the law, unless the person has become voluntarily intoxicated under such circumstances that the person knew or had reasonable cause to know, or disregarded the risk that as a result of the intoxication he or she was likely to engage in conduct constituting a crime within the jurisdiction of the court. It is known widely in municipal law that intoxication can form or lead to a kind of diminished mental responsibility. In the Kowachka trial chamber, the ICTY held that a state of intoxication could only constitute a mitigating circumstance if it was brought about by force or coercion, but not if the defendant produced the situation voluntarily or consciously. The chamber further held that particularly in the context where violence is the norm and weapons are carried, intentionally consuming drugs or alcohol constitutes an aggravating rather than a mitigating factor. Now, this is an interesting twist given by international courts. An explanatory footnote to this tells us that voluntary intoxication as a ground for excluding criminal responsibility would generally not apply in cases of genocide or crimes against humanity, but might apply to isolated cases of war crimes. Thus, the defense of intoxication in and of itself requires that the accused or the defendant's ability to control and assess his own conduct should be completely destroyed due to this intoxication. A further limitation of action liberally in causa principle has been adopted by Article 31(1)(b). This principle is recognized in continental and common law. The underlying rationale of this principle is to prevent a malified intoxication, or rather intentionally bringing about intoxication as a free act, that is actio libera, with a preconceived intent to commit a crime in the resulting state, all in order to then invoke the state as a ground for excluding their personal responsibility for the act that they commit. In such a case, the actor is punished for the crime as though he committed it with full responsibility, and as if he was free and fully responsible in causa, and thus may be blamed for intentional and attributable actio libera, which brought about the state of non-responsibility. Let us now turn to Article 31, Clause 1, Subclause C. In the Rome Statute, Article 31, 1c allows for proportionate and reasonable self-defense and the defense of others against an imminent and unlawful use of force which endangers a person or property of particular importance. Article 31, 1c reads as follows: a person shall not be criminally responsible if the person acts reasonably to defend himself or herself or the body or property of another person or persons. In the case of war crimes, property which is essential for the survival of the person or another person, or property which is essential for the survival of the person or another person, or property which is essential for accomplishing a military mission against an imminent and unlawful use of force in a manner proportionate to the degree of danger that is posed to the person or to the other person or to the property that they seek to protect. The fact that the person was involved in a defensive operation conducted by forces shall not in itself constitute a ground for excluding this person's criminal responsibility under subparagraph 1 of Article 31, 1c. Therefore, the provision, strictly understood, appears to have two basic requirements. One, that there must exist a certain and clear danger to the person or property. This danger must be brought about by the unlawful use of force. There must be a proportionate reaction against it. As to the defense situation, this idea of imminent and unlawful use of force, which produces a danger to the person or property, is itself an arbitrable term. The provision therefore uses an objective ex ante test. According to this test, the situation must exist objectively, not just in the mind of the actor at the time of the counteraction. The subjectification of legitimate defenses, as particularly known in some common law countries, is thereby rejected. The other part of the element of self-defense that you must understand is force. Force may be viewed as a broad term, encompassing physical coercion and psychological threats. The force must be imminent, which means that the danger brought about by the use of force must restrict the scope of the application of self-defense by the actor seeking to bring about a defense of self-defense. The defense or the defensive action must be reasonable. A reasonable reaction must create only such harm to the aggressor as is absolutely necessary in order to repel the danger posed by the aggressor, and the means applied must not be inept or inefficient. Self-defense is also a subjective element, as deduced by the term to defend himself or herself, which means that a defender has to act. This is derived from general principles of comparative law, say Article 31.3 read with Article 21.1c. It is generally recognized that the defender or the person acting in their own defense must at least know about the attack. Whether he must also be motivated by this knowledge, that is, whether the action of self-defense or the will required to protect himself or the other person or the property of the other person also requires knowledge, is arbitrable. We will now look at 31.1 D of the Rome Statute. This deals with the defense of duress. Duress is an implied defense of necessity. Article 31, 1D, the text of which reads as follows: a person shall not be criminally responsible if the conduct which is alleged to constitute a crime within the jurisdiction of the court has been caused by duress resulting from a threat of imminent death or of continuing or imminent bodily harm against that person or another person, and the person acts necessarily and reasonably to avoid this threat, provided that the person does not intend to cause a greater degree of harm than the one sought to be avoided. Such a threat may either be 1. Made by other persons, or 2. Constituted by other circumstances beyond the control of the person. Let us now come to Article 32. Article 32 of the Rome Statute is based on the defense of mistake of fact and mistake of law. There is an important distinction between mistake of fact and mistake of law in a traditional sense. This distinction is still valid in common law. It has been codified, for example, in the Indian law of contracts as well as in Indian criminal law. Mistake of fact is relevant as a rule, but mistake of law is not. It is expressed by the old Roman principle duress nocet or ignorantia juris neminem excusat, which means ignorance of the law is no excuse. A mistake of either type can be relevant only if it negates the mental element, that is the mens rea. Mistake of fact or mistake of law. Firstly, a mistake of fact shall be a ground for excluding criminal responsibility only if it negates the mental element required by the crime. A mistake of law, on the other hand, as to whether a particular type of conduct is a crime within the jurisdiction of the court, shall not be a ground for excluding criminal responsibility. A mistake of law may, however, be a ground for excluding criminal responsibility if it negates the mental element required by such a crime, or as provided for in Article 33, it removes the element provided for the crime but provides a different kind of defense. The ICC had to deal with the possible mistake of law in the very first case that it took for confirmation of charges. This is the Lubanga case. Thomas Diallo Lubanga was charged with a war crime of enlisting and conscripting children under Articles 82B, 26 and E7. He argued that he could not have known that the relevant acts were prohibited, since neither Uganda nor the Democratic Republic of the Congo brought to the knowledge of the inhabitants of Ituri the fact that the Rome Statute had been ratified. The chamber rejected Lubanga's submissions on factual grounds and thus omitted any substantive discussion of Article 32(2), cleverly sidestepping what could have been a very important question of mistake of law. Article 33. Article 33 deals with the defense of obedience to superior order and lays down grounds for defenses of individual criminal responsibility. While the Nuremberg precedent and the subsequent law created therein rejected the notion of superior orders as a ground for excluding criminal responsibility, the International Criminal Court's Rome Statute in Article 33 adopts an approach which on the one hand affirms the traditional rejection of the defense, but on the other hand allows for its application under certain conditions. What are these conditions? Article 33 of the Rome Statute, on a general reading, appears to go as follows. It lays down that superior orders and prescription of law, and the provision itself reads as follows. The fact that a crime within the jurisdiction of the court has been committed by a person pursuant to an order of a government or a superior, whether military or civilian, shall not relieve that person of criminal responsibility unless a. the person was under a legal obligation to obey orders of the government or the superior in question, and B, the person did not know that the order was unlawful, and C, that the order was not manifestly unlawful. Clause 2. For the purposes of this article, orders to commit genocide or crimes against humanity are to be considered manifestly unlawful orders. If we break down the elements of the defense of duress under Article 31(1)(d) of the Rome Statute, necessity and duress are recognized in comparative criminal law as two separate categories of defenses. But the International Criminal Court in the official codification did not consider it necessary to distinguish between the two. In fact, it put the two together, the defenses of duress and necessity. While duress refers to the lack of freedom of will or choice in the face of an immediate threat, necessity is based on a choice of evils within the decision taken in favor of the lesser evil. Thus, in the case of necessity, the unlawfulness of the incriminating act is eliminated by the higher legal interest that the actor has or purports to serve. When applied to the protection of a higher legal interest, necessity permits an act that is usually prohibited and thus is a justification. What is the underlying rationale for understanding this? For duress, the underlying rationale is not the balancing of competing legal interests, but the criteria of Zumutbarkeit. That is, could it be fairly expected that the person concerned would resist the threat? Article 31(1)(d) of the Rome Statute sets out the following qualifiers for the use of this defense, that is the defense of duress. Firstly, that the presence of imminent death or continuing or imminent serious bodily harm against that person or another person or by circumstances beyond that person's control. 2. A necessary and reasonable action to avoid this threat. 3. The intent to not cause a greater harm than the one sought to be avoided. And 4. The existence that the provision contains an objective element, that is the element of actus reus of both necessity and duress. The element of threat applies to both, while necessary and reasonable action is a category of element that applies only to necessity, thus introducing a new subjective condition which relates to the choice of evils conundrum that we spoke about earlier. The defense of duress only recognizes threat that entails physical acts or consequences such as imminent death or bodily harm. The use of the word imminent leads to the establishment of a time frame wherein the harm cannot lie too far in the future. It must be imminent, as in it must be about to take place. Article 31(1)(d) subclause 2 refers to circumstances beyond a person's control. In the defense of duress, that is, the defense of duress cannot be used if the circumstances are within the control of the person. Article 31(1)(d) further classifies this threat as one which must be made by other persons or constituted by other circumstances. Thus, it is made clear that the causation of the serious force or threat must not be the person or the actor himself, but by another person or circumstance that are beyond the control of this person. The second qualifier is often seen as the point of contention, with the phrase necessary and reasonable encompassing both the defense of duress and necessity. This implies that the harm should be limited to that which is absolutely necessary to avoid the threat, and also the reaction which should not cause greater harm than that posed or the one sought to be avoided. This element leads to a blurring of lines between Articles 31, 1 clause C and Article 31, 1 clause D. Conceptually, the difference between self-defense and duress or necessity emerges as a twofold distinction. Firstly, that self-defense requires an attack, while duress or necessity requires only a threat. And secondly, as to the admissible reaction, self-defense usually allows any reaction to defend the invaded, while necessity and not duress only permits a reaction which protects the greater legal interest involved. The third qualifier is a subjective one, and this is based not on the act itself, that is not an actus reus, but on the mental intention or mens rea. The general requirement in comparative law is that the actor's knowledge that he is acting under duress has a solid basis. Now, this condition of mens rea is also connected with the state of mind of the actor. It is also connected with the second element, where the person is required to act necessarily, reasonably and proportionately in order to avoid this threat. Thus, the act is linked to and determined by the threat, and the actor has to act with the knowledge of that threat. Let us now finally talk about the history of the defense of obedience to superior orders. Due to the strict requirement of discipline among the ranks of the military and the clear existence of the doctrine of obedience to a superior, the military doctrine of obedience becomes an imperative defense. This led to the creation of a dilemma for soldiers who, in case of an unlawful order, have the choice of submitting to the illegal order or to commit a crime by defying the order. Therefore, when prosecuted, national authorities were often faced with a clear defense that soldiers would submit, that they were under superior orders. This dilemma led to the creation of two schools of thought. The first based its arguments on the foundation of justice, that such a defense being an absolute defense, while the second school articulated a doctrine of absolute liability, which led to the claim of obedience being rendered null and void. What is important to understand is that this debate rose to the international level. At the time, at the Prussian military code in 1845, the Leipzig trials at the end of World War I, before the First World War, recognized the relevance of a moral choice. It was determined that a subordinate would be punished if, in the execution of an order, he or she went beyond its general scope and executed the order with the knowledge that it related to an act which aimed at the commission of a crime and which the subordinate could avoid. Over time, the moral choice dilemma, that is a moral choice principle, encompassed an objective test. This test came to be known as the manifest illegality principle. Courts applied this test of manifest illegality to determine whether the superior orders were in fact required to be followed or not. After this, international criminal law with regard to the defense of obedience to the superior has evolved considerably, from an outright rejection as an absolute defense at Nuremberg to a more balanced approach under the Rome Statute of the International Criminal Court. However, in all, Article 8 of the Nuremberg Charter, which started out establishing the defense of obedience to a superior, codified that the defendant acted pursuant to an order of their government or of a superior. This fact shall not free the defendant from any responsibility, but may be considered as a factor in mitigating the punishment of the tribunal, if the tribunal determines that justice so requires, which leaves it almost entirely to an arbitrable clause by the tribunal. The more nuanced approach by the Rome Statute treats this defense in a separate article. Article 33(1) of the Rome Statute reads as follows. The fact that a crime within the jurisdiction of the court has been committed by a person pursuant to an order of government or superior, whether military or civilian, shall not relieve that person of individual criminal responsibility unless the person was under legal obligation to obey the orders of the government or the military superior in question. And that, secondly, the person did not know at the time of committing the act under the order that the order itself was unlawful or that the order was not manifestly unlawful. If these three conditions are met, one might be able to establish the defense of superior obedience. Thank you.